Welcome back to the deep dive. Today we are tackling one of the most intellectually slippery and, frankly, practically dangerous areas of criminal law.
We really are.
We're looking at the Model Penal Code, specifically Section 5.03.
Criminal conspiracy.
Exactly. I mean, this is the doctrine that decides when just talking about a crime becomes a crime in itself.
Right.
It's the tool prosecutors use to cast this huge net over entire organizations, but it's also, a minefield of technical requirements.
It is. Conspiracy is often called the darling of the prosecutor's nursery, and for a very good reason.
Why is that?
Well, it allows for joint trials, it gives them evidentiary advantages, and it leads to some very heavy sentencing. But under the Model Penal Code, the MPC, it's not a free-for-all. It's a highly structured statute with really precise elements.
So our mission today is to model a rigorous element-by-element analysis of the statute. We're not just chatting about it. We're going to break it down like we're prepping for a bar exam or a high-stakes trial.
That's the plan. Here's our roadmap for this deep dive. First, we'll hit the definition of conspiracy, so the purpose and the agreement.
Okay.
Second, we'll look at the scope. How far does liability really stretch in a criminal network?
Right, the chain.
The chain. Third, the overt act requirement. When does the agreement actually become actionable? And finally, we'll cover renunciation, how you legally get out of a conspiracy once you're in.
Perfect. Let's jump straight into that first doctrinal analysis, the definition of conspiracy under MPC Section 5.031.
Do it.
So what constitutes the absolute core of a conspiracy charge? What's the foundation?
The general rule is right there in MPC Section 5.03 A person is guilty of conspiracy with another person if, with the purpose of promoting or facilitating the commission of a crime, he does one of two things.
No, literally.
First, he agrees with another person that they will engage in the conduct that makes up the crime, or second, he agrees to aid another person in planning or committing the crime.
So if we break that rule down, it sounds like we're looking at two primary elements.
Correct. Element one is purpose. The actor has to specifically intend for the crime to happen.
And element two?
Element two is agreement. The actor has to agree or believe he is agreeing with another person.
Or believe he is agreeing. I have a feeling that phrase is going to be crucial.
It's everything.
Let's test this rule with a hypothetical case. This one's based on the explanatory note about the unilateral approach.
Yeah, okay, let's hear the facts.
All right, let's analyze the case of State v. Person A. First, what are the legally dispositive facts?
The facts are simple, but very tricky. Person A goes to person B, and they agree to rob a bank together. Person A is all in. But person B is actually an undercover police officer. He has absolutely no intention of robbing the bank. He's just nodding along, to get the evidence.
So person A thinks the agreement is totally real and mutual.
Exactly. He's no idea.
And what was the core legal issue here?
The issue is whether person A is guilty of conspiracy even though there was no mutual agreement because, well, person B was faking it. Can you really have a meeting of the minds if one mind is undercover?
Great question. So what rule of law applies? Please state the full black-letter rule and break it down for us.
The rule comes from the explanatory note for subsection 1 of MPC 5.03. It states that guilt as a conspirator is measured by the situation as the actor views it.
As the actor views it.
Right. So the elements are, first, the actor has to have the purpose of promoting the crime, and second, the actor must agree or believe that he is agreeing with another person.
Thank you. Now for the elemental analysis. Let's walk through this step by step. How do we apply the first element, purpose, to person A?
Okay, so we look at person A's intent. Did A have the purpose to promote the robbery? The facts tell us he initiated it, he was fully committed. So yeah, the purpose element is clearly met.
Understood. Now what about the second element, the agreement? An agreement usually takes two people. How does the analysis work when B is a cop?
This is exactly where the MPC breaks from the common law. The element requires that A agrees or believes he is agreeing. The analysis is totally focused on A's subjective mental state.
So it doesn't matter what the cop is thinking.
Not at all. Even though B didn't actually agree, A believed he did. Therefore, under this unilateral approach to the MPC, the element is met.
And after analyzing all the elements, what's the final conclusion?
Person A is guilty of conspiracy. The MPC doesn't need a bilateral meeting of the minds. A one-sided unilateral belief is enough for liability.
That is a massive shift from how we normally think about agreements. You can basically conspire with a phantom if you believe they're real.
Exactly. It focuses on the danger the individual poses, not just the danger of the group.
Okay, let's move to the next layer of complexity. We know what a single agreement looks like, but criminal organizations aren't just pairs, They're networks.
Right.
This brings us to doctrinal analysis 2. Scope of relationship, specifically chain conspiracies under MPC Section 5.032.
This is often called the scope of the conspiratorial relationship.
So the concept here is the chain. If I conspire with you, am I on the hook for the people you conspire with, even if I've never laid eyes on them?
That is the essential question. And the general rule is in MPC Section 5.032.
Break that rule down for us.
The rule has two main elements. First, the person has to be guilty of a basic conspiracy under subsection 1, so they have an agreement with at least one person.
Got it.
Second, that person must know that their co-conspirator has conspired with others to commit the same crime.
The same crime. That feels like a key limiter.
It is. It's very important.
Let's test this with a chain scenario. We'll call this one the case of the silent smuggler.
All right, lay out the facts.
Let's analyze this case of person X. First, what are the legally dispositive facts?
Okay, person X agrees with person Y to smuggle illegal goods into the country. Now, person Y has his own separate agreement with person Z to transport those goods across state lines once they're in.
And X and Z.
Person X has never met person Z. Doesn't know his name, nothing. But X knows that Y can't possibly do this alone and must be working with someone else to move the goods.
And what was the core legal issue?
The issue is whether person X is guilty of conspiring with person Z, even though he's never met him or even known his identity.
What rule of law applies here? Please state the full black letter rule and break it down.
We apply MPC Section 5.032. The rule states, if a person knows that a person with whom he conspires has conspired with another person to commit the same crime, he is guilty of conspiring with that other person whether or not he knows their identity.
Whether or not he knows their identity, that's explicit.
Very.
Thank you. Now for the elemental analysis. Let's walk through it. How does the court apply the first element, that primary conspiracy?
Well, that one's easy. We're told as a fact that X conspired with Y to smuggle goods, so that base-level conspiracy under subsection 1 is established, element met.
Now, what about the second element, knowledge of others? This is the tricky part. X doesn't know Z.
True, but look at that sub-rule in the text, whether or not he knows their identity. The real question is whether X knew Y was conspiring with someone for the same crime.
And he did.
He did. The facts say X knew Y had to be working with others to move the goods. That's enough. That constitutes knowledge of the expanded conspiracy. Therefore, the element is met.
And after analyzing all the elements, what is the final conclusion?
Person X is guilty of conspiring with person Z. Under the MPC, the chain links them together because X knew the operation had to involve other people even if they were complete strangers to him.
This has huge procedural implications. I mean, if everyone is linked in a chain, can you try them all together?
You absolutely can. And that brings us to a visceral hypothetical based on MPC Section 5.0344.
I want you to picture a mega trial.
Right. So imagine a courtroom with 20 defendants. You've got the boss, you've got the middle managers, the drivers, the money launderers. They don't all know each other. It's a brew.
And why does the prosecutor want this chaos?
Because of the joint prosecution rule in subsection 4. If the conspiracies are, and I'm quoting here, so related that they constitute different aspects of a scheme of organized criminal conduct, they can all be tried together.
And what does that mean for venue, where the trial happens?
That's the scary part, the visceral part for a defendant. Under subsection 4BI, venue can be in any district where an overt act was committed by anyone in the conspiracy.
So wait, if some guy down in Florida buys a burner phone, and that's an overt act, the guy up in New York who's never even been to Florida can be dragged down there for his trial.
Exactly. It creates a jurisdictional dragnet. If you are a link in that chain, you are subject to the venue created by any other link in that chain.
That is incredibly powerful. But you mentioned overt act. That's actually our next big doctrinal hurdle.
Yes. Doctrinal Analysis 3, the overt act requirement under MPC Section 5.03.
The concept here seems simple. Is just agreeing enough to send you to prison, or do you have to actually do something?
The general rule in MPC 5.035 sets up a really important distinction. The rule is, no person may be convicted of conspiracy unless an overt act in pursuance of the conspiracy is alleged and proved.
But there's a massive exception to that, isn't there?
A huge one. The rule continues, other than a felony of the first or second degree.
Okay, so let's test that distinction. We have two contrasting scenarios. Let's call them Case A and Case B.
Okay, let's break them down.
Let's analyze Case A. First, what are the legally dispositive facts?
In Case A, two people agree to shoplift from a convenience store. It's a petty crime, a misdemeanor. After they agree, they go to a store and buy a backpack to hide the stuff they're going to steal.
And case B.
In case B, two people agree to commit first-degree murder. They shake on it, but they're caught immediately, before they buy any weapons, before they do anything else.
Okay, the issue is the same for both. Is the conspiracy actionable? Let's apply the rule of MPC 5.035. Can you state the full black-letter rule and break it down into its testable elements for us one more time?
Sure. The rule is, misdemeanors and minor felonies require proof of an overt act in addition to the agreement. However, first or second-degree felonies do not require any overt act. The agreement alone is sufficient.
Thank you. Now for the elemental analysis for case A, the shoplifters. Let's walk through this. How do we apply the first element, the crime grade?
The sub-issue here is whether shoplifting falls into that big exception. Shoplifting is a misdemeanor. It's not a first or second-degree felony. So the requirement for an overt act stands. It's needed.
Understood. Now, what about the second element, the overt act itself?
We look at what they did. Did they do something to further the conspiracy? Yes, they bought a backpack specifically used in the theft. That purchase is the overt act. It satisfies the requirement.
And after analyzing all the elements, what is the final conclusion for case A?
A conviction is possible. All the elements, including that necessary overt act, were met.
Now let's switch to the elemental analysis for case B, the murder plot. How do we apply the first element, the crime grade here?
We look at the severity of the planned crime. Murder is a first-degree felony. Therefore, under MPC 5.035, it falls squarely into the exception.
Understood. So now what about the second element, the overt act?
It's irrelevant. It doesn't matter. Because the target crime is a first-degree felony, the statute explicitly removes the overt act requirement.
And after analyzing all the elements, what is the final conclusion for case B?
Conviction is possible the moment they make the agreement. The handshake is enough to trigger full criminal liability because of how serious the intended crime is.
So the more serious the crime, the earlier the law is willing to intervene.
Precisely. For something like murder, the law isn't going to wait for you to go buy the gun. The agreement itself is seen as dangerous enough.
Okay, so we've talked about getting into a conspiracy. We have to talk about getting out. This brings us to doctrinal analysis 4, renunciation and abandonment.
Yes, this is covered in MPC Section 5.036 and 7. And it's really crucial to distinguish between renunciation, which is a defense, and abandonment, which is about the statute of limitations.
So the concept is, if you join, can you ever actually leave without going to jail?
Well, the general rule for renunciation in subsection 6 does provide an affirmative defense, but the bar is set incredibly high.
What are the elements to clear that bar?
1. It has to happen after you've already conspired. 2. The actor must thwart the success of the conspiracy. And 3. It has to be a complete and voluntary renunciation of their criminal purpose.
Thwart the success, so you have to stop it. And what about abandonment under subsection 7?
Subsection 7 is only for the statute of limitations. It just determines when the clock starts ticking for you. To abandon, you either have to advise your co-conspirators that you're out, or you have to inform law enforcement.
Okay, let's test this with the cold feet case.
Alrighty.
Let's analyze the case of the reluctant robber. First, what are the legally dispositive facts?
A conspirator agrees to a bank heist. But the night before, he gets cold feet. He calls up his partner and says, "I'm out. I can't do this." Then he just stays home. The partner goes ahead and commits the robbery anyway.
We have 2 issues here. Let's take issue 1. Does he have a renunciation defense against the conspiracy charge?
Okay, let's apply the rule from MPC 5.036.
We've got the rule. Let's jump right to the analysis. Walk us through the elemental analysis for that key element of thwarting.
Right. The element requires the actor to thwart the success of the conspiracy. So we have to look at what his actions actually accomplished. He called and he quit, but the robbery still happened.
So he didn't stop it.
He didn't stop it. Therefore, he failed to thwart the success of the conspiracy. The element is not met.
And after analyzing the elements, what is the final conclusion on his defense?
He has no affirmative defense.
Yeah.
He is still guilty of conspiracy because he did not actually stop the crime from happening.
That is harsh. Just saying I'm out is not enough to save you from guilt.
Not if the crime goes forward. You have to
Yeah.
actively stop it. Call the cops, disable the getaway car, do something that actually works.
Okay, now for issue 2. Has the conspiracy terminated for him when it comes to the statute of limitations? This could matter if, say, 5 years pass before anyone gets caught.
Let's apply the rule of MPC 5.037.
Again, we have the rule. Let's go to the elemental analysis for abandonment. How do we apply the element of advising?
The rule requires that the actor advise those he conspired with of his abandonment. Here, the facts are clear. He called his partner and explicitly said, "I'm out." That direct communication absolutely satisfies the element of advising his co-conspirator.
And after analyzing that, what is the final conclusion regarding the statute of limitations?
The conspiracy is terminated as to him. And what that means is the statute of limitations clock starts ticking for him the moment he makes that phone call.
So he's still guilty of the conspiracy, but if the police wait too long to charge him, he might get away because of the statute of limitations. Meanwhile, his partner who did the robbery is still on the hook.
Exactly. It's a small lifeline, but it is not an acquittal. We have covered a massive amount of ground. We've dissected the definition, the scope, the overt act, and the exit strategy.
We have. It's a lot.
For our listener who's trying to synthesize all of this, maybe for an exam, let's bring it all together.
Absolutely. Here is your diagnostic checklist for MPC 5.03. When you see a conspiracy fact pattern, just go through these 4 steps.
Step 1.
Check the definition. Is there a purpose to promote the crime? Is there an agreement? And remember, under the MPC, look for a unilateral belief of an agreement. You can conspire with a fake accomplice.
Got it. Step 2.
Check the scope. Are there other parties involved? Does the actor know that his co-conspirator is working with others on the same crime? If the answer is yes, he's linked them in the chain. That's subsection 2.
Okay. Step 3.
Check the crime grade and overt act. Is the goal a first or second degree felony? If yes, the agreement alone is the crime. If no, if it's a lesser crime, you must find proof of an overt act, like buying supplies or scouting a location.
And the final step, step 4. Check for renunciation. Did the actor just walk away? Because that's only abandonment for the statute of limitations. To have a real defense, they must have thwarted the conspiracy. They must have actually prevented the crime from happening.
That is an incredibly powerful framework.
It really helps cut through the noise.
I want to leave you with one final thought on this whole unilateral approach. Under the model penal code, you can technically be guilty of conspiracy that only exists in your own mind. If you sit in a room and agree with an undercover agent, or even, I suppose, a hallucination, as long as you believe there is another person agreeing with you, the law says you are a danger to society.
It penalizes the intent and the social danger of that individual, and it treats the agreement as a window into a dangerous mind.
A window into a dangerous mind. That is conspiracy law in a nutshell.
Thank you for listening to The Deep Dive.
Until next time.